I'm going to go ahead and share my screen here. And let's see here. Okay, so hopefully everybody's seeing the screen. We have an hour and a half to cover assistance animals, everybody's favorite topic. There's always a lot of confusion, controversy, frustration around assistance animals, and there are a lot of different laws that apply to different spaces with assistance animals, and they're called different things and treated differently in different spaces. So we're going to try and dispel some of that confusion and spend some time walking through the HUD guidance that HUD issued in 2020, and hopefully at the end have some questions. If there are some relevant questions as we go along, I'll try and take them, but I also want to be cognizant of the time and keep moving, and there's a lot to cover. So we'll go ahead and get started with that. So there are a lot of different laws that apply to animals needed for disabilities in different spaces. We have Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, the Washington Law Against Discrimination, which is our own state law, and then the Federal Fair Housing Act, which is what we're primarily going to be talking about today, but making some distinguishing from a couple of the other laws and how they treat animals. So just briefly, Section 504 of the Rehabilitation Act applies to recipients of federal funding. So housing providers that receive federal funds have an obligation to provide reasonable accommodations, equal access, and integrated settings for people with disabilities. So 504 is there to make sure that our federal dollars are distributed in such a way that people with disabilities can use and enjoy the services and facilities as well. So if it's a federally funded housing property, Section 504 is going to apply. Receiving a Section 8 voucher doesn't turn it into a federal property. These are usually more like federal grants or housing authority, public housing owned properties, things like that. Then we have the Americans with Disabilities Act. This is also a federal law, and this applies to public and common areas of housing. So it does apply to some areas like the office or in other areas that are open to the public if an event room is available for rent or use by the public. And then the ADA also applies in other public spaces such as restaurants, grocery stores, going to the mall, just out and about in public. So the federal ADA is enforced by the U.S. Department of Justice, not HUD, the U.S. Department of Justice. And it has a very limited definition of a service animal, which is a trained dog to provide a task or service for somebody with a disability, as well as miniature horses. A lot of people are surprised to hear that. Miniature horses are smaller than some of the big breed dogs. They can be housebroken and they live about 3 times as long. So there is a growing movement to use miniature horses instead of, for example, a lab that needs to be, replaced every 10 or so years because of their lifespan. But in the ADA, no emotional support animals are allowed, and no cats, ferrets, birds, anything like that. So that's our public spaces, again, restaurants, grocery stores, as well as, office areas of housing. And then we have our state law, Washington Law Against Discrimination. And this applies to both places of public accommodation, just like the ADA. It applies to employment discrimination and housing. So this is all rolled into our state law. And in accommodations in public areas and employment, only trained dogs or miniature horses, again, are permitted. In housing, the definition of service animal in the Washington Law Against Discrimination specifically does not apply. So you need to use a reasonable accommodation analysis in determining whether or not an animal should be allowed in housing under the state law. This is the definition under the Washington Law Against Discrimination about service animals. The service animal is any dog or miniature horse individually trained to do work or perform tasks for someone with a disability. And then if you note the red sentence, the legislature added this in 2019 and said this subsection does not apply to other sections of the Washington Law Against Discrimination, with respect to housing accommodations or real estate transactions. So again, only employment and public accommodations. We don't apply the service animal definition. In the past, we had landlords and housing providers not allowing assistance animals, emotional support animals in housing because they said our state law said it needed to be a service animal. And so the legislature tried to rectify that with taking this definition out of the housing sphere. And then we come to the Federal Fair Housing Act, which is primarily what we're going to talk about today, applies to housing, applies to all housing, whether it's federally funded, private housing, rentals, long-term motel stays, anything that can be deemed a dwelling for somebody is likely to be covered by the Fair Housing Act. There are a couple exceptions for smaller landlords, but generally, if there's more than 4 units, generally the Fair Housing Act is going to apply, and accommodations need to be granted for all kinds of things, including assistance animals. Assistance animals in housing falls under reasonable accommodations. There's no definition of assistance animal, service animal, emotional support animal, anything like that in the Fair Housing Act. It's simply a reasonable accommodation analysis, and we're going to really walk through that today. Additionally, the Fair Housing Act provides for people with disabilities to request reasonable modifications. Those are structural changes to a unit, like putting in grab bars or a ramp. And then there's some design and construction requirements to make sure that properties built after 1991, March of 91, are accessible for people with disabilities, particularly using wheelchairs, making sure that doors are wide enough and ramps are in place if needed, and so on. But we're going to focus on the accommodation aspect of the Fair Housing Act today. So just generally as a roadmap, we're going to really get into the nitty-gritty of how do you analyze a request for an assistance animal in housing under the Fair Housing Act. But in general, with respect to any kind of reasonable accommodation, you want to keep in mind these 3 points. Is there a disability? The person needs to have a disability to ask for an accommodation. Is there a nexus, a connection, a relationship between the disability and what's being asked for? What's being requested needs to be needed because of the disability. And then, is it reasonable? And we'll look at some of the things that make a request reasonable or not reasonable. So if you remember nothing else about reasonable accommodations, these are the 3 steps: disability, relationship to the disability or nexus, and reasonableness. Okay, so I'm going to walk through just a couple steps of what an accommodation analysis is, and then we're going to get into the HUD guidance, the 2020 guidance specific to assistance animals, where HUD really walks us through how you analyze a request for an accommodation for an assistance animal. But generally, here again are the 3 steps: disability, nexus, and reasonableness. And then if it's unreasonable, it doesn't need to be granted. And things that factor into unreasonableness are if the accommodation request would be an undue financial or administrative burden, cost a lot of money for the housing provider, or require them to do a lot of paperwork on a daily basis, those kinds of things. Typically an accommodation, should be a one and done. The request is made, there's some discussion back and forth, and then it's pretty much over, and shouldn't cost a lot of money for the housing provider. And then it also can't be a fundamental alteration to the business. So for example, if a housing provider is not in the business of providing supportive housing, it's probably not a reasonable request to ask for that housing provider to come in and administer medications, take somebody to the grocery store, et cetera, more like supportive housing would do. So those things factor into reasonableness. If it's reasonable, the accommodation should be granted. If it's not reasonable, if the housing provider determines it's not reasonable, then they should engage in an interactive dialogue, a discussion, a back and forth communication with the person requesting the accommodation to see if there are alternatives to what's being requested. If it's, for example, a parking space, we don't have that one available. You want to reserve space near your unit. That one's already taken. There's one over here. Would that work for you, etc. So an interactive dialogue is encouraged by HUD if you if a housing provider deems that the accommodation is not reasonable. Okay, so this brings us now to how do assistance animals fit into the whole reasonable accommodation scheme of analysis under the Fair Housing Act. So HUD issued guidance in 2020. It's about 19 pages, and it's in a step-by-step If this is true, then you move on to this, and then you can ask these questions. And if those are true, you go here. If not, then go there. So it's 19 pages. I've tried to summarize that we're going to go through today. So there are the subject of this memo is assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. And again, it applies to all housing providers, whether federally funded or privately funded. It doesn't address any of the other civil rights laws like Section 504 or ADA. So housing providers may have additional obligations beyond the Fair Housing Act to comply with federal laws for making accommodations and modifications. And it doesn't govern airlines and common carriers. Those are addressed by other laws and regulations. So many of us see the news reports of somebody getting on an airplane with a turkey or a peacock or whatever. That's might be entertaining, but none of that pertains to housing. So don't take your instruction about assistance animals from what's going on in the air carriers. Those are other laws and regulations, and just to sort of confuse the whole scheme of things, but doesn't apply to housing. And this memo from HUD does not apply. And then HUD says that we should also read the guidance from HUD on assistance animal together with its fair housing regulations, and it has a joint statement with HUD and DOJ from 2004 about reasonable accommodations under the Fair Housing Act. So if you don't already have that or know about it, that's a really good resource to go to in just trying to determine how to analyze or make a request for a reasonable accommodation in the Fair Housing Act. So again, assistance animals are simply an accommodation under the Fair Housing Act. So HUD says that is still good guidance as well. So take a look at that, or have that in your arsenal of resources. And the guidance from 2020 was prospective. It shouldn't be used for housing providers to go back and reassess all the accommodations that they've already granted in the past. So it's prospective going forward from January 2020. And it's divided into two sections. The first is the more lengthy. It has 5 parts, and that's really how do you determine if a request for a reasonable accommodation for an assistance animal should be granted. And then there's a shorter part at the end that gives some guidance on how to document the need for assistance animals in housing. So that can be useful if you're involved in trying to help somebody verify their need for an assistance animal, get a letter from a healthcare provider, or you're the person who's actually writing the verification. That can be some good guidance. So 2 sections, and we're going to walk through that today. So what are assistance animals? You notice that I'm using the term assistance animals. There's a lot of terms relating to animals needed for disabilities out there. You've probably heard service animal, emotional support animal, therapy animal, assistance animal. HUD has started using the term assistance animal as an overarching term of an animal needed for a disability, because it includes both service animals, which we'll get into that definition as well, but that's more like a seeing eye dog, something that performs a task for somebody, does work for someone with a disability, or other animals that maybe provide emotional support. They're not specifically trained as service animals, but they do provide some kind of benefit or service or support for someone with a disability. So assistance animals covers all of this. They're not pets, however. So pet fees shouldn't apply in housing, pet rent, pet insurance, pet deposits. None of those things should apply to an animal needed for a disability. Okay.
Marley,
So, yes.
Marley, would it be okay if I jump in here just a minute?
Yeah, please do.
On that slide? Okay.
Oh, let me go back. Yeah.
Yeah. Sorry, I didn't mean to
Nope.
stop your roll here, but I just wanted to clarify. So basically what Marley's telling you here in this bottom where it has all these names, right? Therapeutic, emotional support, companion, assistance, da, 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 da. It really doesn't matter what the animal is called. The assessment is done on the person who has the disabilities. It is not done on the credentials of the animal. Okay, so the animal can have a vest or not. The animal can have a certificate or not. The animal can have its owner calling it whatever name it's calling it, pet, psychiatric dog, whatever it's calling it. The reasonable accommodation analysis and breakdown is about whether the person has a disability and what it is they need and what it is they can verify they need. Okay, that's all I want to kind of just get to the, like, really clear on that. Okay, thank you.
Thank you. Yeah, please jump in whenever.
Okay, thanks, Marley.
Yeah. Okay. Okay, so we're going to look at the steps here. So HUD says when presented with somebody in housing who wants to have an animal for a disability, you start out first with determining if the animal is an ADA service animal, an Americans with Disabilities Act service animal. And again, those are dogs individually trained to perform work or tasks for the benefit of somebody with a disability. And additionally, there's another section of the ADA regs that allow miniature horses. But if you're dealing with a dog, you need to determine, is it an ADA service animal? Other species of animals, cats, ferrets, birds, fish, are not service animals under the ADA. Okay, so if yes, if it is a dog, we're going to go on to question 2 in the guidance. If no, it's not a service animal. Okay, cats can't be service animals. You move on to part 2, where we look at assistance animals as reasonable accommodations under the Fair Housing Act. Okay, so still looking at, is it an ADA service animal? Is it trained, is it a dog that's trained to perform work or tasks for someone with a disability? And they give some examples, again, pulling a wheelchair, providing stability or balance for somebody, again, a seeing eye dog. If yes, further inquiries are unnecessary. So if you can see that this person is using a dog and it is providing work for that person, such as pulling wheelchairs, stability, seeing, hearing, etc. If you can see it, stop. You don't need to do anything more. It's a service animal. You don't need to ask questions. You don't need to get verification. But if you're not sure, because a lot of times it can perform tasks that you don't know what it's doing, you get to go on and ask 2 limited inquiries. Okay, so again, in determining if it's an ADA service animal, if the disability in work or task are not obvious, you can ask 2 limited inquiries. Is the animal required because of a disability? If the person says no, then it's not a service animal, and it's not even going to be an assistance animal under the Fair Housing Act of any kind. If it's not needed for a disability, you don't have to allow it. But if they say yes, it's required because of a disability, then the next question is, what is the work or task that the animal is trained to perform? And if the person identifies at least one thing, one action that the animal, the dog, is trained to take, which helps their disability, besides emotional support, they can't say, you know, it helps my anxiety, makes me feel better, things like that, keeps me calm, needs to actually do some kind of task. And it could be actually for an anxiety disability if it's doing something like, there was a Fred Meyer case where somebody brought a dog into Fred Meyer's. When the person got anxious, the dog had been trained to walk in a little circle around the woman to give her some space. And there was testimony about this, that the dog actually did this in court. So could still be for a mental health disability, but it needs to be performing some kind of a task. So if somebody identifies one task that it does, or one way in which it works and helps their disability, then it's a service animal. So either you see it, it's obvious, they're using it like a seeing eye dog or for balance, you don't ask any questions. If it's a dog, they say it's needed for a disability, it's not obvious what it's doing for the disability, then you get to ask what work or task it's trained to do. And if they tell you something, that's it. And don't ask any more questions, that's the end of it. So that's the ADA service animal definition. However, or analysis. However, if it's not needed because of a disability, it's not a service animal, and if it doesn't perform any work or tasks, if they say it doesn't do anything, or they say it does emotional support, then it's not a service animal, but it may still be, and it wouldn't be allowed in public spaces like under the ADA and restaurants, etc. But it may be an assistance animal that still needs to be accommodated under the Fair Housing Act. So it's easy if it's a dog and it's obviously trained to do something for a disability, or the task is identified of what it does for a disability. But if not, if you're dealing with a cat or emotional support animals, now we move on to this part 2. So this is how you analyze the reasonable accommodation request under the Fair Housing Act for assistance animals other than service animals. And this is where we're really going to use that 3-point analysis. Is there a disability? Do they need what they're asking for, the assistance animal, because of a disability? And is it reasonable? And HUD just expands a lot on that. But this is really that 3-point analysis here. So when an animal does not meet the definition of a service animal, the housing provider needs to determine, has the individual requested an accommodation to get or keep the animal in connection with a disability. The person who needs an accommodation or an advocate for them needs to ask for the accommodation. The housing provider shouldn't go around asking people, do you need an accommodation? It's on the person who needs it to request it. It can be oral or written, doesn't need to be in writing. But it's helpful if it is. And when we advocate for people, we will 9 times out of 10 put it in writing, send over the request to the housing provider, just so that everybody knows what's being requested at the beginning. The accommodation can be requested at any time before or after acquiring the assistance animal. And this is a big thing to note, because a lot of housing providers, as Shannon might jump in and tell you, get very frustrated when they say we have a no pets policy, no animals policy. The person checked no pets on their application, and then suddenly 2 months down the road, there's a cat peeking out the window, and the housing provider feels like they've been tricked and lied to. And that could be a couple of things. One, maybe it wasn't even prescribed by a healthcare provider when they moved in. It's a new thing that's needed for their disability. 2, because there's a lot of discrimination against people with assistance animals. They may have been hesitant to share that they have an assistance animal, and technically an assistance animal isn't a pet, so people aren't always forthcoming. But HUD clarifies here that a request for an assistance animal as a reasonable accommodation needs to be considered even if the request comes after they get the animal and they brought it home and it's peeking out the window at you. So the housing provider needs to consider the request even if made after bringing the animal into housing, or even after a termination of tenancy is initiated. So once compliance notices have started going out and a termination of tenancy have been issued, if somebody at that point says, I need a reasonable accommodation, this is an assistance animal, then the housing provider needs to consider that.
Marley?
Yes.
One brief question that was in the chat and regards fees for animals. In this case, they're asking, can a pet screening fee be requested? So not a pet deposit, not a pet fee, but a screening fee. Want to answer that?
Yeah, not related to the animal. For the person, sure, they can have the screening, but and have to pay the normal fee that's applied to everybody. But if it's related to verifying, is this an assistance animal or not, they should not have to pay a fee for that. You can't impose terms or conditions on having an accommodation. And so I don't think HUD would allow that. I think that would be a problem.
Thank you.
Yep. Okay, so again, determining has an accommodation request been made. There can be an accommodation for more than one animal. And I think that was a question I saw in the chat a little bit ago.
Correct. Yeah.
Right. Okay. So the request, HUD says, yes, it may involve a request for more than one animal. For example, a person with a disability may have disability related need for 2 animals. Maybe they do 2 different things. One's used for balance, one's used for emotional support. One, is trained to pick up something, fetch things, one does something else. Or maybe they're both for emotional support. And that seems at first, counterintuitive. Well, they're doing the same thing. Why do they need 2? But if it's emotional support for a mental health disability, and this person is psychologically attached to both of these animals that they maybe have already when they move in, and they're told they have to get rid of one, I mean, that can really exacerbate their emotional distress and their disabilities. And, we've come across many people that would almost rather move out of their house and live homeless or in their car with their animals than get rid of the animals. So even though 2 animals might be doing the same thing, if getting rid of them would exacerbate the disabilities, then they probably both need to be allowed. There also can be multiple people in the household that have animals needed for disabilities. So there can be more animals for that reason as well. At some point, though, you do get into the reasonableness aspect. If somebody has 10 animals, is that reasonable given noise, smell? There might be municipal zoning laws that limit municipal laws that limit the number of animals. In Spokane here, depending on your square footage, you can have, I think, 4 domestic animals, including cats and dogs, but not other kind of barnyard animals. But so if there's a local ordinance, generally the housing provider can fall back on that. The person could make an accommodation request to the local jurisdiction, and if they get an exception, then the housing provider might need to allow it. But it does become a reasonableness issue. Yeah.
Someone jumped in with, what about one of them is aging out? So you have an aging out dog and you get a younger dog. Can you do that?
HUD, I've not seen that specifically addressed. I know that happens. And again, dogs, have limited lifespans and, 10 years or so on average, the bigger breeds. There's nothing specific from HUD on that. And so again, I think if they're able to get a verification letter that says that they need this other animal, they're in the process of training one and the other one is has very limited days, then, I think it all comes down to the verification if they get a
right. Some of these are very case by case situations, right? What does the healthcare provider letter say? What is the disability related need, et cetera? Someone wants to know if a property has a 2-pet limit. How do you do it if they've got a third one that's supposed to be the emotional support? That whole, how do we label the animal kind of thing? We got 2 pets actually, but 1 support, 2 support, etc.
Housing providers can have rules regarding pets. So they can limit the number of pets. They can say only 2 pets. They can limit the species, the size, the weight, the breed, cats only, dogs only, under 30 pounds only, no animals, whatever. They can have pet rules. But an accommodation is an exception to a rule or a policy. So if the rule is, you can have 1 pet only, and the person has 1 pet and an assistance animal is needed for the disability, I would argue that they get to have both if they can provide the verification for the emotional support or assistance animal in addition to the pet.
Great. Someone also addressed the question of, I have a client who requested a companion for their animal, an RA so it's an RA for the animal to have an animal. Right. So that's not an accommodation for the person, that's an accommodation for the animal, and that's not something that the Fair Housing Act would support.
Right. There's no accommodations for animals. The accommodations for the person. What does the person need? Okay, so now we're moving into part 3. So first was, is it an ADA animal? If not, you move on. Okay, has a request for an accommodation been made? You've been presented it verbally, in writing. It might involve more than 1 animal. Okay, so you've got a request before you. Now, does it need to be granted? Okay, this should sound familiar, right? Number 1, is there a disability? Okay, if you don't have a disability, an accommodation doesn't need to be granted. Disability under the Fair Housing Act, as well as the ADA, is a physical or mental impairment that substantially limits 1 or more major life activities. So it can be a physical disability, a mental disability. Major life activities are things like working, lifting, breathing, walking, that people without disabilities are normally able to do. And if one of those things is substantially limited, then it can be a disability under the Fair Housing Act or the ADA. These are examples that HUD has said are usually in all cases a disability, deafness, blindness, they've got a whole list here, but there can be many other things that are also disabilities. And then this is where our Washington state law against discrimination jumps in again, because it's written very similarly, the housing sections, to the Federal Fair Housing Act, but the disability definition is much broader. It recognizes temporary disabilities that the Federal Fair Housing Act does not. So if somebody has a broken hip and it's expected that they're going to recover during the time that they have the broken hip, they could ask for a reasonable accommodation. And doesn't matter if it can be mitigated or unmitigated. Again, under the Federal Fair Housing Act, the case law is sort of whittled down what can be a disability if it's mitigated. If you can use a device or medication or something that, you know, minimizes your symptoms, then it may not be a disability anymore. But our Washington law is very, very broad. So any kind of diagnosable medical condition is likely to be a disability under our state law. And so people can ask for accommodations then. Okay, so, you know, we go on to question 5. So did the person have a disability? Well, how do we know? Is it an observable disability? Can you see it? Are they using a wheelchair, a cane, a walker, you know, a red and white striped cane? Is it obvious that they have a disability? Or do you already have information to know that they have a disability? For example, when they went through their verification process, they provided an SSI letter showing that they get SSI or disability related income. Then you know they're disabled. So if that's the case, you don't get to ask any more questions. Here's some things that HUD says, again, may be readily observable: blindness, deafness, mobility limitations, etc. Sometimes they are, sometimes they're not, but if it's readily obvious, you don't get to ask any more questions about the disability. You get to move on then to, do they need the animal? But there are a lot of disabilities that are not obvious. So if it's not obvious or the disability is unknown, HUD says you get to ask for some information to verify that they have a disability, and then also the disability related need, that need part, if that's not obvious also. Okay, so has the person requesting the accommodation provided information that reasonably supports that they have a disability? So how do you verify the disability if it's not obvious? Again, maybe determination of disability from a government agency, they provided that. They get a housing voucher that's specific to disability, a HOPWA voucher if that's disclosed. Those are things that show that the person has a disability. And if it's not obvious, if they haven't already provided information showing that they have a disability like SSI verification or something, then a third-party verification, typically from a healthcare professional, somebody like a physician, a psychiatrist, a psychologist, a nurse practitioner, etc., can verify the disability and the disability related need. Housing providers can't require the verifier to use a specific form. Often that's the case, that they have a form that they send over to the doctor. Sometimes it can streamline things, but if the person already shows up with a letter from their doctor, they shouldn't have to go back to the doctor and make an appointment 3 months out to see the specialist to get a letter that says, yes, they have a disability and need the animal. So it can't be required to be on a specific form. The verifier doesn't need to provide it in a notarized statement. They shouldn't be asked to sign under penalty of perjury, because that has a cooling effect on healthcare providers, you know, prescribing things for their patients that they feel are going to be beneficial for them. And it shouldn't provide the diagnosis or detailed information about medications, symptoms. You know, housing providers can't ask about the nature or severity of disability. So they shouldn't be asking, you know, what's wrong with you? What's your diagnosis? What are the medications you take? Have you been hospitalized, etc.? They just get to ask for, do you have a disability? And then a verification that the person has a disability can come back if it's not obvious.
Hey, Marley.
Yeah.
Shannon here.
Yep.
I'm just going to jump in. The chat's going wild with some questions. Well, not wild, but you know, it's getting a lot of questions peppered there.
Yep.
And so I just wanted to kind of loop back around to say, all this is to say, yes, there are landlord-tenant laws out there, and that is not what we regulate, and that is not what we interpret or have jurisdiction in, right? Those are state laws. There's a lot of the reason this topic gets hot is because people are like, well, what's reasonable? And what about that new carpet I've just put in there? And if I was the housing provider, I wouldn't like that. And la, la, la. Don't tell me what to do with my property, right? This is all that stuff. So there's a lot of like pushback on whether people have disabilities, how to determine they have a disability. Is it severe enough to the, you know, what causes it to require an animal? What kind of animal? How, la, la, la. Let me just say, if the animal is disruptive, if the animal runs loose and jumps on people, if the animal barks or lunges, if the animal were to misbehave and ruin some part of the property, the landlord housing provider has recourse, right? Because that's about behavior.
Yeah.
Whenever anything's about behavior, whether it's the guest of the tenant, or the tenant's guest animal, right? In this case, an assistance animal.
Yeah.
If the behavior goes sideways, the landlord or housing provider has recourse. The recourse is to issue a 10-day notice to say, you're in violation of the lease. You are A, parking on the lawn, B, creating noise at 3 a.m. C, your dog, whether it's an assistance animal, emotional support animal, service animal, whatever it is barking nonstop and disrupting everybody in the unit. Your dog lunged at someone in the elevator. Your dog X, Y, and Z. Your cat is, scratching the door jamb gone. That stuff receives a 10-day notice, period. If the person doesn't comply, they can move on to the next step under landlord-tenant laws, right? So the person with the animal, assistance or otherwise, has to mitigate that behavior. That behavior cannot just go crazy and go on because it's carte blanche an assistance animal. Just because it's an assistance animal doesn't mean it can pee off the balcony on other people's balconies. Just because it's an assistance animal doesn't mean any of those things. There are ways that landlords have recourse on that stuff. And I always tell landlords, look, do your due diligence like you would with anything else. If you're reticent about having an animal there, I understand. However, this person has a civil right to have this animal because they've verified it. It's for their disability. That's verified. Everything's verified. So why don't you blacklight your apartment before they move in? Blacklight their apartment before they move out. If you have problems with carpet, if you have problems with damages, you get to charge for those at move out, right? So there are common sense ways to sort of dispel all of this. Well, I feel out of control as a housing provider if I am forced to have an animal in there, right? And that should cool people down a little bit on both sides. And we tell that also to the person who's asking for the animal. You can't just have this animal and then don't do anything for this animal, right? And don't take care of it, don't feed it, don't attend to it, don't control it. No, you have a responsibility to do that as well. So hopefully that cools down both sides and both understand they have a responsibility. Neither one of them is just carte blanche, do as you please. Okay.
Thanks, Shannon.
Thanks.
Thank you. Yeah, thanks for monitoring the chat. I know there would be a lot of questions. Yep. One of the things that HUD did with its 2020 guidance was address internet verifications a little bit, probably not in as much detail as we would like, but as the digital age is, advancing and more technologies make remote verifications possible and remote healthcare possible. It's hard to keep up. The laws have a hard time keeping up, but HUD did give a little bit of guidance. And so this is what they have to say about internet verifications. They acknowledge that there are websites out there that sell a certificate or some kind of a licensing or registration for people who want to usually pay a fee, answer some questions, or participate in an interview with a healthcare provider remotely, and then get some kind of document about their animal. Now, such documentation by itself, HUD says, is not sufficient to establish a disability or disability-related need. So if it is just a certificate about the animal, Fido is on the National Service Animal Registry. That has nothing to do with, does the person have a disability and do they need that animal? So somebody can pay all the money they want. And unfortunately, a lot of people with limited income get, roped into paying money that they don't have to get something that says that their animal is a registered service animal. And that's not going to suffice to verify their disability or need for it in and of itself. So if the certificate or letter just says something about the animal and nothing about the person and their disability and need, then that alone isn't going to qualify. However, again, with the remote technology that we have now, there are legitimate ways that people engage with healthcare providers remotely through Zoom, et cetera, the internet. And this can be particularly helpful for people in rural settings, people who are homebound, have difficulty with transportation, et cetera. So if the letter that comes from this remote healthcare provider verifies that the person has a disability or needs the animal, then that can be sufficient. And so what we encourage is when people contact us with these kinds of questions is look at the letter. Is it all about the animal? You know, that's great. This person paid some money to have their animal on a registry, which is not required. But if it doesn't say anything about the disability or the need for the animal, then that's not going to be enough. But if it does, and it's got some health providers credentials on there and they put that on there, if I'm the housing provider, I'm going to allow that, because who wants to get into dueling experts in a lawsuit and, you know, is it really needed, et cetera. So once you've got the documentation that says it's needed for a disability, even if it comes from a healthcare provider in another state, I would accept that if I were the healthcare provider. So, or the housing provider. So we've got a little guidance from HUD, probably not as detailed as we'd like, but a little bit there. Okay, so if the person requesting the accommodation has provided information that they have a disability, we move on to question 7. This is really the nexus, again, the connection. Okay, we verified the disability either through a third-party verifier, through observation, or some other information they provided that they have a disability. Now we're into the nexus area. Does it provide, does it do tasks, provide work, or emotional support? So unlike the ADA, service animal, assistance animals can do a variety of things. It just needs to do something related to the disability. And this verification, again, can come from a licensed healthcare provider. And there's some examples of who can write that. If the person is unable to provide verification of either the disability or that they need the animal for a disability, that could be grounds for saying, sorry, we can't grant the accommodation. However, if it's provided, then you've got verification of the need as well as the disability. Now we're into the reasonableness area, and that's sort of where the memo turns, the guidance from HUD turns to looking at different types of animals. So if you have a disability and a verified need for the animal because of disability, you look at what kind of animal it is. If it's a domesticated animal, commonly kept for pleasure rather than commercial purposes, then you grant the accommodation. And the examples they give: dog, cat, small bird, rabbit, hamster, gerbil, other rodent, fish, turtle, other small domesticated animals. So that's the end of it right there. But there are also some unique animals somebody may ask for. Unique animals are not common household animals, many of them kept for commercial purposes, like a barnyard animal, or exotic animals like a monkey or a kangaroo or something like that. These are not common household animals. These aren't automatically off the table, though, because if somebody can show that they need a unique animal as an accommodation, then it should still be granted. You'll see in the green highlight here, if the information from the healthcare provider confirms that without the animal, the symptoms or effects of the disability will be significantly increased. Again, getting rid of this animal is going to cause a lot of emotional distress and exacerbate their disabilities. Then the animal should be allowed. So it's easy to grant. If it's one of the other domesticated animals, you automatically grant it. If it's an exotic animal, you can get a little bit more detail, but if you've got a healthcare provider saying that the disability is going to be exacerbated by getting rid of it, not having it, then it should be granted as well. So the animal, now again, still in the reasonableness area, can only be refused if the specific animal poses a direct threat to other people and property. So you can't make generalizations. Somebody comes along with a big dog, oh geez, it's going to be aggressive, or it might have a louder bark, or it might, you need to know something specific about that specific animal, that it's going to be a direct threat, that at its last place it bit somebody, or was very aggressive, or something like that. So you need to know something about the specific animal. You can't make generalizations. And that applies to breed as well. Just like housing providers can have a no pets policy, but have to make exceptions to allow assistance animals, they could have a policy that says no pit bulls, no Rottweilers, no whatever, dangerous breeds they deem. However, an accommodation is an exception to a rule or policy. So somebody shows up with a pit bull mix, unless you know something specific about that animal, needs to be allowed. Some housing providers will say, well, my insurance has a dangerous breeds list, doesn't allow certain breeds. Well, insurance is covered by the Fair Housing Act, just like sales, rentals, all of those lending, mortgages, any kind of housing transaction is likely to be covered by the Fair Housing Act. And that does include insurance. And HUD has a memo for that about insurance providers need to grant reasonable accommodations, again, for animals needed for disabilities. And if not, they'll be referred to Department of Justice for investigation. So if you're up against that kind of dangerous breed insurance issue, there's a memo for that. And then if the threat can be eliminated or reduced through some kind of a mitigation, you may still need to allow it too. So if now the dog's wearing a muzzle, maybe it's a case-by-case reasonableness thing, but HUD says you can only refuse the accommodation if the specific animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through actions the individual takes to maintain or control the animal, keeping them in a secure enclosure, etc. So that's all reasonableness. Now that we're onto the general considerations, the last part of the first section of the memo. Remember, there's two sections of the memo. This is part 5, the last part, general considerations. HUD says best practice, make a determination on an accommodation request promptly. And generally that means within 10 days of receiving disability need verifying documentation. Don't wait on it because denying it waiting on it can be deemed a denial eventually. If you never get back to the person, eventually they're going to feel that it's been denied and file a fair housing complaint. So stay in communication with the person who's requested the accommodation. Let them know if you need to consult counsel or supervisors, etc. But let them know that their request is being addressed. And then before outright denying an accommodation, HUD encourages housing providers to engage in a good faith dialogue called the interactive process. And this is really, again, where alternatives can be discussed. Is there something else you haven't gotten your animal yet, maybe, and you're asking to keep, I don't know, a giraffe, whatever. Would it be possible for you to have a different animal? Then you can have a little bit of wiggle room to discuss. Once they already have an animal, then you need to make a decision on it. A giraffe, not going to be allowed in city limits, etc., under our code, or granite, whatever it is. But if they don't have it already, that's where there may be a little bit of discussion about the type of animal that they get. But rather than just denying it outright, have some discussion. And again, maybe there's some mitigation issues. They're asking for an accommodation to have their assistance animal. Something came up about it being, barking at the last residence. Okay, well, is there some kind of mitigation that could be made to, a muzzle, some training, crate training, whatever. Again, just rather than saying, no, we don't give reasonable accommodations, having that discussion at the point where you're going to refuse it is encouraged by HUD.
Okay, Marley.
Yeah,
I've got a few questions. I think if I wait till the end, it's going to be quite a few, too many. So
okay.
if I can throw a few with right now. So can a tenant be asked or forced or demanded to sign an ESA rules document?
I believe housing providers can have rules. They can't, it's not the same as the pet addendum. It should be a more narrowly tailored set of rules, but I think they can, yeah.
Okay, so if
within
they
reason, yeah.
So if the tenant refuses to sign those, what can happen?
I mean, again, there's no, as much detail as I'm giving you here, this is what HUD's told us in 19 pages, and there's always so many more facts. And so, again, if they're very reasonable, like needs to be under your care and control, needs to, quiet hours, that kind of stuff. I think that's all reasonable. If they don't sign it, boy, I don't know. That's a tricky one, because what's going to happen? They don't sign it. The risk is then the person goes and files a fair housing complaint. I don't know where HUD's going to come down on that.
Right.
I think you can definitely ask for it and present it. And if it's reasonable terms, hopefully the person will sign it. I can't assure what will happen if you drop dead if you say you must sign
Right.
it or else. So.
Well, and typically housing providers are only, I thought, allowed to require whatever a municipality would require. So for example, if it says all pets or animals that are used for disability are required to have a licensure, are required to have shots, that kind of stuff, but you can't require additional things like they have to have their voice box cut, they have to be fixed, they have to be this, that, the other thing.
Yeah, and that just comes from, you can't impose terms and conditions on a reasonable accommodation. You can't make it really difficult or impose barriers for somebody to have an accommodation that's needed. So you shouldn't, a housing provider shouldn't be requiring those kinds of things for an animal. However, if there is a third party entity like a government agency that says you need to have a rabies vaccination for your animal, then the housing provider can require that, unless I guess the person can go and get an accommodation from the third party municipality, but that's between them and the person with the disability. So if there's a law or a regulation out there that says something needs to happen regarding the animal, I think the housing provider is going to be justified in relying on that. Hey, law says you have to have this vaccination or this licensing or whatever.
Right.
But
so I guess
add
I would
extra terms.
Yeah, right. Adding those extra terms. So I would say sometimes too, it helps to put in a different type of disability related request or a different disability auxiliary aid. So for example, if a housing provider said, well, in order to have that wheelchair or in order to use that walker, you need to have extra special this or that, right? That would be discriminatory. I mean, you can't require different terms and conditions for someone who has an auxiliary aid.
Right.
Well, this wheelchair might damage something, therefore we're going to charge you a deposit to use your wheelchair in our housing. Okay. Timelines for a tenant to get back to a housing provider on getting the verification. Is there any kind of timeline?
For the person to provide the verification?
Correct.
Yeah, no, nope, there's not. We've got the guidance from HUD, 10 days from receiving the verification, make a decision. But again, I think we're in that reasonableness sphere. Somebody has their animal, they're asking for it as an accommodation. They have an appointment to see their doctor. The appointment's coming up next month. I think it's reasonable to say, please don't charge me the fee or terminate me or whatever until I go and see my doctor next month. If it's 6 months down the road, if it's yeah, I think it's a
right.
a reasonableness.
Yeah, and it's kind of within that interactive process, right? That's expected, right? So, yeah, there's a lot of really, it looks like there are more housing providers on here than I would have expected. A lot of housing provider questions, like can a housing provider require an ESA be spayed? Well, you couldn't require that of anything unless it's required by the municipality, but most municipalities try and sweeten the deal by saying we'll give you a reduced rate to license that animal if it's spayed or neutered.
Yeah.
So,
but I don't think you can require it for an assistance animal.
Right. I don't think you can, I don't even know that you can require it for a pet, but okay. You can say, no additional animals. If it does birth a bunch of puppies or something, then you'd have action to give a 10-day notice. And if someone gets 4 10-day notices in a 12-month period, they're open for termination. So, those are all landlord-tenant laws about behaviors, right? Behaviors rather than fair housing laws. Can you give a 10-day notice if the person refuses to have the animal on a leash, even though they've not signed the agreement to be on the leash? So, all of these are very case by case. If a person has quadriplegic disabilities and cannot hold a leash, but has voice command of the animal, what would you do, right? That's a very specific situation. They might have voice command of the animal and not be able to use a leash. Would you still give them a 10-day notice? Probably not a good idea if they've got 10, if they've got control of the animal and it's not misbehaving and it's not jumping up on anybody and they're still having someone else pick up the dog waste and that kind of thing. There's no violations there.
Yeah.
So again, case by case by case by case.
But the animal needs to be under the care and control of the person. They shouldn't be barking at all hours, shouldn't be, if it's off leash, shouldn't be running and jumping on people. Yeah, you can give compliance notices for all that kind of stuff.
Okay, thanks, Marley.
Yeah, and this I mentioned earlier, you can't charge a fee, a deposit, a surcharge for an assistance animal. You can charge them after the fact if the animal actually damages the unit. I think I saw there was a comment. I was just trying to scan some of the comments, but I know I haven't seen them in detail about the black light, and a lot of people.
Yeah, there were questions. The idea of, well, people with SSDI income are on fixed income, so even if they do damages, we can't go after them. That would be the case whether they have an animal or not. And if you decided, well, let's just don't rent to people that don't have garnishable income, then you're going to disproportionately affect people who are disabled and probably run afoul of the fair housing laws, because you're saying, basically, I'm not going to rent to anyone who's disabled because I'm going to assume that they're going to automatically make damages, and I'm going to assume that I can't recoup my cost on that.
And any deposit, may or may not be sufficient for any damages that
anyone does.
So,
yeah.
A housing provider can set the deposit amount of what they feel is, the average or the reasonable amount or the going market amount to recoup their losses of any. But that would apply to, if they spill wine on the carpet, break the windows, whatever, the deposit can go for that, and it may or may not cover it. But yeah, a lot of people have fixed incomes, and you can't not rent to them just because they have an assistance animal. So
yeah, we got seniors on fixed incomes, we got vets on fixed incomes.
Yeah, and if they ruin something else in the apartment too, the deposit may not cover it all.
Right.
Okay, let's see here. What else do we have? Okay, pet rules don't apply. So again, as far as weight, size, breed, species of the animal, the person with the assistance animal is responsible for arranging for its feeding, maintenance, vet care, controlling it, etc. So HUD says that, so it needs to be under their care and control. Then this is the second section of the memo, and this is the best practices section for documenting the need for assistance animals. It's not nearly as lengthy, it's just a couple of pages, but HUD says that this may assist people with disabilities in explaining to their healthcare professionals what kind of information is needed to support a reasonable accommodation request. If the disability or disability related need is not obvious or known by the housing provider, it needs to be verified. So these are some best practices, not requirements, but they suggest that the verification letter have the patient's name, indicate whether there's a professional relationship with the patient or client. Often there's a statement such as, I'm Sally Smith's housing provider, or a healthcare provider, or doctor, or whatever. A signature, date, contact information, and then verification of the disability. Whether the person has a physical or mental impairment, whether it substantially limits one or major life activity. So it could go as far as include the Fair Housing Act definition. I'm so-and-so's healthcare provider, and Sally Smith has a physical impairment that substantially limits one or more major life activities. May say that, may just say she has a disability under the Fair Housing Act, under the ADA, those kinds of things, but it shouldn't and doesn't need to spell out her diagnosis, that she has cerebral palsy or whatever her condition is, what medication she takes, etc. And then as far as the need for the animal, the best practice guidance is verifying that the person needs the animal because it does work, provides assistance, performs a task, or provides therapeutic emotional support to alleviate a symptom or effect of disability. And then the type of animal. So she needs a cat that's going to provide emotional support. So that is a best case, a best practice letter. But if a housing provider gets a letter that says, I'm so-and-so's doctor, she needs a cat for her disability, I would accept that. I think that that's going to be sufficient. You've got the need, you've got disability right there. But it is helpful if it spells out a little bit more. But sometimes healthcare providers go way the other way too and include all kinds of diagnosis and confidential information. If you get that, if you're on the receiving end of that, don't share it with anybody else who's not involved in the verification, in the analysis and decision making on the accommodation. Don't tell other people, keep all that information confidential. But a lot of healthcare providers don't know what to put in the letter and sometimes go overboard the other way.
Okay, Marley, sorry,
Yep.
I did forget one of the questions and they popped it in there again. Thank you. Verifiers.
Yep.
Verifiers who provide the letters. Who can those persons be or entities be?
Okay. So we go back to that 2004 Reasonable Accommodation Joint HUD and Department of Justice guidance memo that was referenced in the beginning. That HUD says, read that with this. In that, HUD has a pretty liberal list of who can verify a reasonable accommodation. Now that memo is not specific to animals, it's any kind of reasonable accommodations, but it's a very broad list and it includes, you know, doctors, nurses, people like that, but also peer support workers, you know, case managers, social service agencies, things like that, and other reliable third parties.
Yeah.
Position to know about the disability. It's very
independent
broad.
living specialist.
So when we go back to the, go
right.
ahead, Shannon, go ahead.
That's it. That's it.
Okay, so when we go back to the definition, again, a physical or mental impairment that substantially limits one or more major life activities. That's a functional definition. That's, you know, can this person walk across the floor? If you can visibly see, you're the roommate, the household member, geez, I can see mom can't get out of bed. You know, she's got this hip condition and she can't, you know, walk or work or whatever. That's readily, you don't need to be a doctor to diagnose and see that. And so sometimes the people closest to us are the ones that are most able to verify that they have a disability. Now, in reality, if somebody files a fair housing complaint and says, you know, my daughter verified that I have this disability definition, they're going to be deemed a non-credible witness, a biased witness. So usually the third party should be somebody more at arm's length, in some sort of a professional therapeutic capacity. But HUD mentions peer support groups. So somebody who's in AA, maybe Alcoholics Anonymous, they have a sponsor that can verify, you know, that they're doing really great now. And, you know, that person's not their doctor, but that person can perhaps verify their disability and a need that they have. So that memo is very, very broad. Now, in this 2020 guidance, HUD seems to limit it a little bit. It doesn't say only these people, but the kinds of examples it gives are more healthcare type people, you know, nurse practitioners, physician assistants, doctors, psychologists, things like that. But it's a non-exclusive list, and read with the 04, I think if you get an accommodation request from somebody, a verification from somebody who is at, you know, in some kind of a professional or therapeutic role, I think that you should deem that sufficient. So that's where we're at with that. It looks like HUD's narrowing it a little bit, but particularly if you've got any kind of a mental health counselor, you know, somebody like that, I think that's going to be sufficient for an animal.
Roommate question on allergies.
A roommate. Well, roommates have to figure it out amongst themselves typically. So it depends who places them. If they go into a place and lease something together, that's going to be their own struggle in terms of what they're going to allow or not allow. The housing provider doesn't, you know, should allow it if one of them asks for it, but then it's between the roommates if it's going to happen or not. If roommates are placed by some other entity, that's where it gets a little trickier, because there are some housing providers that will place roommates into housing situations, and where the housing provider is making decisions about who's going to room up, that can be a little trickier. If somebody is renting out their own house to a roommate, the Fair Housing Act stops at the door. So if you have just a, you know, person only owns one house, and they get to decide if they're going to rent to somebody who they want to rent to, essentially, because they may eat kosher, they may not, they may have allergies, they may feel more comfortable with someone of their same gender, etc. So it gets a little tricky. It comes down to who's picking the roommate. But yeah, if it's a one landlord, one house, and the person's having a roommate come in, essentially Fair Housing Act stops at the door. They can refuse somebody because of their own allergies. Roommates that pick themselves, they have to work it out, just like, are we going to be messy and do the dishes or not, or whatever? Are we going to be loud? They're going to have to decide that. Housing providers that place people, that is tricky if people are sharing common areas. I think the Fair Housing Act can come into that area, but it gets tricky. So I know that was kind of a squishy answer, but
Yeah, but it is, again, one of those case by case.
Mhm.
And of course, someone's asking about college dorms. How do they fit with animals?
They're covered by the Fair Housing Act. Same thing, covered by the Fair Housing Act. Universities need to grant reasonable accommodations, and most of them have policies at this point about accommodations and assistance animals. So they need to grant accommodations as well. And there have been cases, I've seen a lot of cases about universities not allowing somebody to have an assistance animal, and HUD and DOJ will pursue those cases.
Right. I wanted to bring up also with housing providers, condos and housing associations often don't see themselves falling within this, but they are within this.
Yep. We get a lot of confused condo boards and homeowner association boards that don't know fair housing law. So yep, applies in those situations as well. Other questions there? There's too much here in the guidance.
Yeah, I guess someone asked, and I don't understand. I mean, I guess, okay, can we track which animals are service and which are ESA in the tenant files? And I'm like, I guess if that serves some purpose, I'm not sure what it would serve, but I don't see that there's any. I mean, you would want to document, just like you document who's the roommate, who's in the household. You would document that stuff, whether it's a service animal or ESA animal or a pet. I guess you could put that note in there too. I'm not sure what it serves, but okay.
Yeah, the only thing I can think of is if a complaint is filed against the housing provider, you don't allow assistance animal, you didn't allow me to have my assistance animal here. Sometimes the evidence that will come back, the defense presented is, no, we've rented to, all these other, 50 people with assistance animals. Just this one specific person didn't didn't income qualify, or whatever the real issue is. And so in terms of being able, I guess, to, have that, but yeah, otherwise I don't really know what the need would be for that.
So now all the dwellings are kind of springing up. Shelters, hotels, motels, how are they covered or not?
Okay, so Fair Housing Act applies to dwelling units, and a dwelling has a very broad definition. It's something that's intended as a residence for one or more persons, and land that's zoned for that, essentially. So single family or multifamily land, zoning, and the land's not developed yet, but the sales transaction could be covered under Fair Housing Act if it's in those kinds of residential zones. But as far as buildings, so intended as a residence for one or more persons, the easy ones are, again, houses, apartments, condos. What am I missing here?
Mobile home parks.
Mobile home parks, thank you. Yep. But a lot of things can become a dwelling too. You really want to look at the length of the stay. That's what HUD will analyze. They'll look at several factors. Is the person able to return to the same room, the same bed? Or do they have to get in line? So if it's a shelter where they get to have a room, have a bed, and they're there for several weeks, that's their residence for all intents and purposes. If they don't have another residence, they're in the homeless shelter. That's a residence. If it's a homeless shelter where they are not guaranteed a bed, they got to reline up every night, they can't leave their belongings, that's less likely to be deemed a dwelling unit as a residence for somebody. Extended stay motels. If it's just a motel for a getaway for the weekend and you've got your residence elsewhere and you're just on vacation, that's not going to be covered by the Fair Housing Act. If the motel is your residence because you have nowhere else to live and you're staying there paying week by week, month by month, the longer the term, the more likely that is to be a dwelling. Right.
So this also, just as another example, domestic violence shelters would fall into that.
Yep. Mhm. Yep. Yep. As far as continuing just the last couple points of the best practice for verifying, HUD suggests if the person's dealing with this unique animal situation, including a little bit more information about the unique animal, that, you know, when you last consulted with the patient, the unique circumstances justifying it, you know, they need this animal because of XYZ. Whether they have reliable information about the animal, whether they specifically recommend this animal. Again, not requirements, but best practices for verifying. So that is the 19 pages of the HUD guidance memo. And I can tell from the questions, I mean, it only opens up more questions, right? And so these are really, really case by case. I think you need to at least go back to those 3 basic elements. You know, first, if it's an ADA dog, you allow it. You can see the disability, you can see they're using it, performing a task for a disability. You don't know anything that's made this animal dangerous. They've articulated some disability related task that does, you allow it. After that, you move into the accommodation analysis, and it's, is there a disability related need, and is it reasonable? Again, did it bite people at the last place or not? So that's, I mean, that's really the gist of it. But as I can tell from the questions and from lots of other trainings we do, you know, there's always, every situation is different, and you're just going to have to go through the steps and analyze. HUD does have a tool.
I put that
Perfect.
interactive tool in the link way up in the beginning of the chat. So
Okay.
it's about, I don't know, maybe eight posts down, where I put in the link for the interactive tool that HUD just developed. I also added the link for, let's see, the DOJ HUD guidance on reasonable accommodations, which does a lot of Q&A.
Right.
And if you think of an animal just as any other accommodation, right? That's, I know it can be hard to think of it that way, but if you read the RM memo from DOJ and HUD, that's in there. I also put in a HUD page on reasonable accommodations that's got some questions specific to animals. Someone here says they have landlords that say they don't care about HUD law. They'll pick the tenant who doesn't have the assistance animal when they, you know, do multiple applications. What can you do?
For something like that, you could refer it to us. One of the tools that we have as a fair housing agency is testing. And if you're on the west side of the state, the Fair Housing Center Washington, based out of Tacoma, is a similar agency to ours, also does testing. But we can do testing. And so if you feel like there's a housing provider that's not that's picking and choosing amongst people without assistance animals, we can do a test, and we can have 2 people similar in their profiles contact the housing provider, inquire about the availability of a unit. What do you have available? They just ask very open-ended questions. You know, how much is the rent? What's available? I see you don't have pets. I have an assistance animal. Oh, we don't allow animals. Well, I need it for a disability as an accommodation. Nope, not gonna, you know, they give the person an opportunity to say that they would accept it. But if they don't get a response, but the other tester does, if they're told there's no units available, and the tester without the animals told, you know, there's 5 units available, you can move in tomorrow, you know, and we can do a series of tests and show that pattern, then that can result in a complaint. Our agency files both complaint-based, we do complaint-based testing. So somebody comes to us and says, I feel like I was denied because of my race, religion, disability, etc., including having an assistance animal. We can do some tests, and it may exonerate the housing provider. It may show, I don't know what was going on the day you talked to them or applied, but they told our tester that they would accept the animal. Accept assistance animals, they passed, or they may walk right into it and say, you know, nope, we're not going to take assistance animals, or they may do different treatment, not respond to that person, or lie and say nothing's available, whereas the other person's told that there is availability. We also do audit testing, periodically sampling what's going on in the 17 counties that we serve. So if you have a problem with a housing provider and any kind of a fair housing discrimination issue, then, you know, let us know. And if it's in our eastern side of the state, we can do some testing.
And so I guess just want to explain, because I recently saw a HUD finding, you know, every once in a while HUD will publish these things out that say, hey, we charged this landlord with this. And I recently saw one, and it kind of begs the question, well, what happens if you have a fair housing complaint filed against you? Well, if you have a fair housing complaint filed against you, there's an investigation that unfolds between HUD or Washington State Human Rights Commission, because they're considered equivalent bodies in this state. So either one of them can investigate it. If they investigate it, they're looking for whether or not this has occurred, right? Whether this speaks to alleged discrimination as complained about. And the penalties, can be high. If HUD discovers, yes, in fact, there was a landlord saying straight out, I don't care about the fair housing laws. I don't care what HUD says. This is what's going to happen. It could be in the thousands of dollars that there you go, Marley, you put that. Thank you for putting that in there. So the one I saw recently was in Oregon. A couple were acting as landlords management of their property, and that's exactly what they did. I don't care. It's my property. I'll do as I see fit. And HUD charged them, and they had a settlement of $17,000. $17,000, you can really do something with your property with $17,000. Maybe the damage doesn't ever warrant that. So allowing the animal in that cost benefit analysis would probably be better to just allow the animal and move on.
I'm scanning the questions here just to see if there's anything that we missed. Yeah, so we have a few minutes left. Is anybody else have anything they want to pop in the chat that we didn't cover, we glossed over?
Someone who has an assistance animal or an emotional support animal has advised that they don't ever list the animal on the application for housing because they'll never get in their experience. And then they present the letter once they've been approved. So
yeah, I believe it. I understand why people do that, because we do hear a lot of stories about people being treated differently, and our testing, bears that out a lot of times. So I understand why they do it. I think the housing provider can ask, is there a pet? And if they say, no, I don't have a pet, because it's not a pet, they haven't lied. I don't think the housing provider really, and the housing provider needs to know about the pet to see, does it comply with all their other rules? Is it the size or breed or species or whatever that they allow? They're going to charge them the pet fee if they have one, or pet deposit or pet rent. But really, the housing provider doesn't need to know at that moment about the assistance animal.
But what if the application says, do you have an animal?
Yeah, that's a tough one. I would say I have an assistance animal if possible, but yeah, I get why people don't disclose. Yeah, HUD says if the person comes in, HUD doesn't address what they say in the application, but HUD says if the request is made after the move in, you still need to consider it. So I think even if they've said, no, I don't have an animal, and then they move in and after day one, here's my animal, I think you need to assess that accommodation request.
Some people are asking about liability if they write a verification letter.
Yeah, I get that, that people are concerned about that, but yeah, I don't think you're warranting that the specific animal is safe or has gone through behavior training or anything like that. You're saying the person needs the animal is what your verification is. So I've not seen the healthcare provider being held liable. If anything, it's going to be the person with the animal if they didn't adequately control it, if they let it run at large and it hurt somebody.
I also can see in the chat, there's a lot of people saying, well, can you ask a broad question like, what animal do you have now? What will you bring in after move in? What will you, et cetera. I have to say, I am a housing provider, full disclosure, right? I've been a landlord, but I would be hesitant to do those kinds of questions, because if I transferred it over to a different protected class, let's take family status, for example. What children do you have? What children do you plan to bring into the house after you move in? Do you plan to be pregnant? Do you plan to adopt? Do you plan to foster? I mean, don't you think that would have a chilling effect on people with families or family status, right? Like, I think I'm walking a very fine line that I'd be looking at disproportionately discouraging people with children from moving into my property. And if you're asking all those kinds of questions about whether or not you're ever going to, are you ever going to have a disability? Do you think your disability might require you an animal in the future, et cetera, et cetera? You're having a chilling effect on anyone applying for your units. So I'd be really careful. I wouldn't do it. I wouldn't do it as a housing provider. I think it opens me up for a lot of risk. Who do you associate with? Do you associate with people who are brown or black? Do you associate with anyone of this kind of religion? I mean, just transfer another protected class onto it. And I think you got to be careful.
Yeah, and why do you need to know? Because whether they say, yes, I do plan to bring in an assistance animal, you're still going to have to allow it. And so it seems like the question is just fishing to keep people, to screen people out. A lot of times people don't know too what they'll need in the future. They may need an animal one day and not the next, or vice versa. So disabilities change, needs change, and so I don't think people can anticipate that or be expected to disclose that. So somebody's asking about the presentation. Yep, we're happy to share the slides. Mm-hmm.
Yes, you can submit an RA at any time, right? So can you help the person submit an RA so they're in compliance right off the bat? Absolutely. I think that would be fantastic. Yep. Fantastic, because you can ask at any time of tenancy, pre, post, during, at the point of eviction, doesn't matter. I have to also just throw this out there. I used to Airbnb rentals, right? And so I never knew who was going to be in there. I never knew who was going to be in there. They were only going to be in there short term, so maybe my risk was a little bit lower. But I had to get really used to not knowing anything about the person, right? And who they were, what they did, what their race was, what their national origin was, any of that stuff, their criminal history. I couldn't know any of it. And Airbnb says they do some screening on their end, but who knows? So that bears this person one time called me and said, I have a property management company and they're running my properties for me. And they rented it out recently, and I asked them some questions about who moved in there, and they said, we can't answer those for you because that's a fair housing situation. And she goes, what do you mean? And they said, well, call Northwest Fair Housing Alliance and ask why. So she called me and she said, I just want to know about the people in my property. I just want to know about them. And I said, well, what do you want to know? Well, I don't know. I want to know what they do for work. I want to know where they came from. I want to know, how many are there and that kind of stuff. And I said, but see, what you need to know is whether they meet the credentials. Do they have enough income? Do they meet the credit score? Do they meet the requirements that you gave to the property management company? Because all that other stuff, you can't really ask. You can't really ask. And I know it feels weird, but you can't really ask, like, to what end? Why would you, if you were asking that, what is that about? You have to ask yourself, what is that about? Will you have a different sense of them? Will you get a stereotype? What is it that you're looking for to know who they are that are in that property, right? I don't know. I just want to know. I just want to know because it's my property. It's my property. I just want to know about them. I want to know about them. Well, all you really can look at is, do they pay the rent on time? Are they taking care of the property according to the lease? And did they qualify based on the criteria you set, which has to do with 3 times the income or 4 times the income, credit score, the rental history? If they've got a rental history that meets your criteria, that's all they need. So yeah, we do have that desire, but we have to remember what it is that's underneath all of that. It might be that we want to classify, we want to put a stereotype in there, or we have a bias towards certain things.
So as we're getting close to time here, I appreciate that perspective, Shannon. She's an advocate, but also a housing provider. Another resource that we didn't mention, we have on-demand classes on our website. that are available 24/7, and we do have one on assistance animals, and it's very similar to this presentation today where we walk through the HUD guidance. So that is available on our website, nwfairhouse.org, on our training page. So that's another resource. We have an article that I endeavored to condense the 19 pages of HUD guidance to about 6 pages, and I think that's on our website also. So a couple more resources there. And I guess the takeaway is we've got this guidance from HUD. I love when HUD gives us guidance. It, helps dispel some of the uncertainties. But as we've discussed, there's still a lot of, case by case and gray areas. But at least this will hopefully give you a starting point. The other guidance I guess we can look to is there are lots of complaints still being accepted and investigated by HUD around the country and Department of Justice. And so, as a cautionary point, denying assistance animals or service animals is definitely on the radar of HUD and DOJ. And so I think if you just if you're the housing provider, do your due diligence and, do I know they have a disability? Have they provided verification of the need? Is there anything to show that allowing this specific animal is going to be unreasonable? Nope, you allow it. And then you employ your landlord tenant tools as you would for any tenant for compliance with being a good tenant. Hopefully there's no problems. If there are, then you can give the requisite notices. But just again, cautionary, HUD is actively taking these cases, and every other day I receive a press release from HUD or another fair housing agency about these. So thank you for having us today. I really enjoy talking to this group, and please reach out to us, particularly if you're on the east side. I mean, if you're on the west side, that's fine too, but we serve 17 counties in eastern and central Washington. Please feel free to reach out to us. Is our contact information in there? I'm not sure if it was on the last slide or not.
It isn't. Well, I don't think it was
on the last slide, but you'll get the slides.
Yeah.
And you can put our website maybe on there we go. Perfect. Okay, well, thank you so much all. Really appreciate it. Great questions. Thank you for the time, and have a great day.